So I mentioned there's a small bit of the MiFID II directive, and that small bit is in Article 16, primarily Article 16, paragraph 7, which, after requiring firms to keep records, it says they will include recording of telephone conversations or electronic conversations which relate at least to transactions that are concluded on own account and the provision of client order services that relate to receiving, transmitting or executing client orders. And critically, they include those that are intended to result in these transactions regardless of whether they actually do. Firms have to take reasonable steps to make sure they carry out the correct recordings, and that, having kept the records, they must do so for at least 5 years. They must provide them to the client on request, and they must provide them to the regulator or other authorities on request. The devil's in the detail, of course, and the detail is in what is known as the MiFID II org regulation, because this regulation that was made under the directive, under the powers in Article 16, sets out this is what we require you to do. They have to establish, implement and maintain effective policies for recording telephone conversations and electronic communications. And those policies have to be in writing. They have to be fit for purpose for the business of the actual organisation. So you don't have an off-the-shelf one-size-fits-all policy. You take what you need to do and you adapt it to your business. But what all the policies must have in common is that you identify which internal and external communications are subject to the recording requirement. You work out how you're going to record them. You second guess when there might be exceptional circumstances and you're unable to record them, and what you will do in those circumstances. Also, the management body has to take responsibility for this. They can't just decide that some poor individual somewhere in the compliance department will just sort this. The management body has to take responsibility, have oversight of it, and control the policies and procedures and be interested in how they're complied with. MiFID II organisational regulation says firms have to keep and update a record of individuals who have approved devices, whether they're those provided by their firm or their personal devices, and effectively ban them from using anything else and from using any methods of communication that cannot be recorded. Obviously, it's important to train the employees on what they've got to do, otherwise you can't say they should have known. And there is an obligation on firms to do periodic checks to see that it's going properly, to see that they're picking up what they should do, and how often and how you monitor the records, again, got to be proportionate to your business and to the risks. You've got to be able to show the regulators, if they ask, that you've got your policies, your procedures and your management oversight correct, and you've got to keep those records in a durable medium. You've got to be able to replay or copy them in an unalterable, undeletable form and have them readily accessible and available to those who ask. So where are we now? Well, in some ways, many UK firms started off on a better footing than firms elsewhere in Europe, because FCA introduced a recording requirement back in 2009, and it's currently in Chapter 11.8 of the Conduct of Business source book. And that requires firms to record communications about certain trading activities and keep them for 6 months.
I hope you found that a useful workshop. If you want further information, please go to smarsh.eu/resources and you'll find further information to do with this topic.